A boy and a girl who are of the age of majority go in a mandir and perform saptapadi or marriage rituals in front of a priest. Whether this is a valid marriage? Yes, it is a proof of valid marriage, though it requires registration afterwards under Indian law. But yes, it is a proof of marriage, and this is an example of custom as a source of law. Hey everyone, welcome to Law Simple and Pure. I'm your host Dr. Vaishali, and in today's lecture, we are going to learn custom as a source of law with proper examples and proper case laws. While writing your answer, always follow a pattern. Start from introduction and end with a conclusion. So what are we going to cover in today's lecture? And you have to provide all these points before you begin your actual answer. So before you begin your actual answer, make a paragraph that these are the points I'm going to cover in my answer, and then one by one explain each and every point so you do not forget any point which needs to be discussed. So what are the points? Number 1, introduction. Number 2, sources of law as per the Indian law. Number 3, what is custom? What is the definition of custom? Number 4, classification of custom or types of custom. Then number 5, various theories relating to custom as a source of law. Number 6, certain qualities which are required in a custom to be a source of law. So what are the qualities? One by one we are going to discuss all of them, and then we are going to conclude. Point number 1, introduction. In India, sources of law are multiple. There are so many sources of law. What is a meaning of sources of law? Source means a point from where law comes in your system, right? So there are various sources of law in India. Legislation or act of a parliament is a source of law. Judicial law is a source of law, right? Then custom is a source of law. Religion is a source of law. International law is a source of law. So there are so many sources of law in India, and custom is one of the sources of law. As per Article 13 of the Constitution of India, law means any rule, regulation, bylaw, order, ordinance, notification or custom having a force of law within the territory of India. So custom is a valid source of law which is recognized under Article 13 of the Constitution of India. Apart from Article 13, is there any provision regarding custom as a source of law? Yes, entire personal law is an example of that. In personal law, in Hindu law, in Muslim law, in Christian law, there are so many sections which are actually derived from customs. So it is, though it is codified by legislature, it is actually a customary law. Plus, in law of contract, a big part of customs of merchants are respected in that law. Means customs were there, they are codified in contract law. Customs were there, they are codified in the form of Hindu Marriage Act or Muslim personal law. So got it? So customs are there which are respected by law. In Indian Constitution also, there is a part of customary law. In contract law, there is a part of customary law. In property law, there is a part of customary law. Entire religious law or personal law in India, marriage, succession, divorce, adoption, maintenance, all these matters relating to or a part of personal law, majority of that is derived from customary law. So custom is a source of law in India. Now you know what to write in introduction, that in India sources of law are multiple. Source means a point from where law comes, and then discuss all the sources in introduction, and then custom as a source of law. So provide reference of Article 13 and the other laws which we discuss now. Point number 3, what is custom? Custom is the oldest source of law in India and in the world also. So custom is a rule which is followed by people for centuries or for generations. That rule is called as a custom. People follow it customarily for a long period of time, and that law or that rule is called as custom. Next point number 4 is classification of customs. There are various types of customs, like local customs are there, then national customs are there, there are international customs as well. But all the customs cannot become a part of law. Considering our topic, there are two major types of custom having sanction and customs without sanction. Customs with sanction means which are respected by law, which are codified by law, and which are considered as a law. For example, Hindu Marriage Act. Lots of customs relating to marriage are codified by law. So that is an example of custom with sanction. So what are the customs without sanction? Local customs like wearing a sari or wearing a hijab or putting that red dot on forehead. Okay, so these are the local customs, but they are not part of law. So some customs are just customs and some customs are backed by law. And apart from this, there are again so many customs like local customs which are followed in a part of Rajasthan or part of Maharashtra or part of Gujarat. So some local customs relating to food habits, relating to clothing, and also they are local customs. Some are national customs which are followed throughout the India, and then there are some international customs which are followed by international community. But customs which we are going to discuss are customs with sanctions, or customs which are respected by law, or customs which are actually turned into a law by the process called codification. So that is a real source of law from our perspective, or which is important for us today. Next point is point number 5, or theories of custom as a source of law. Two major schools in jurisprudence, they discussed custom. One school supported it, one school opposed it. So according to historical school, custom is a real source of law. Customs are followed by people over generations. They follow it because they are comfortable with those customs. They like it. They peacefully enjoy those customs, and that's why custom is a real source of law, because it actually comes from people. So according to Henry Maney, custom is something which is organic to society. According to Puchta, customs are enjoyed peacefully and then law comes. So legislation is a later stage and custom is a main source of law. So historical school is a school which supported custom as a source of law to a great extent. According to Savigny, law develops like a language, and custom also is so natural to people. Language comes in operation because people need it, and similarly customs are there because people need those customs, people follow those customs. So custom is something which is natural for people, and that's why it is one of the biggest source of law according to historical school. Then second school, or positivism provided that all the customs are not a source of law. Only those customs which are respected by legislation, okay, or by the legislature. So customs which are converted into a law by the process of codification, those are the sources of law. So there are two theories: custom as a source of law without any codification, that is historical school, and second school is positivism, which provides that custom can get a force of law only by the process of legislation or by the process of codification. Point number 6. Certain requirements to constitute a custom as a source of law. Whether all customs are a source of law? No. All the customs are not a source of law in India. There are so many customs which are actually banned by law. For example, system of sati, which was there in India, which was a part of customary law, which is banned by law, right? System of triple talaq, which was a part of custom, okay, which was there in law, but it is removed from a law. So lots of customs are respected by law and lots of customs are actually removed by law. For example, custom of child marriage. Child marriage was customarily done in a large part of India, but now that custom is eradicated or abolished by Child Marriage Prevention Act. So custom of sati, custom of triple talaq, okay, custom of child marriage, custom of bigamy, which was there in Hindu law, these customs are eradicated or abolished by law. So every custom is not a source of law, only some customs. And which are those customs? These are the essential ingredients which must be there. Number 1, antiquity. Antiquity means it must be old. It should be a really old custom. It should not be a new custom. It must be something which is followed by people for generations. For example, custom of Saptapadi, which we discussed in introduction, okay, a part of marriage ritual, it is followed by people for centuries, okay, and that's why it became a part of law. So custom should be really, really old. People should not be able to recall from when it is started, because people are following them throughout the years, because it is really old and which is followed by people for generations. So number one is it must be very old. Number two, it should be moral. It should not be immoral. So customs which force women in prostitution, okay, it is banned because it is against morality. Custom of child marriage, it is an immoral custom and that's why it is removed. So all the customs are not respected by law. So custom should be moral. In a case law, Mathura Naikin versus Ishu Naikin, Bombay High Court provided that purchasing young girls for forcing them into prostitution is immoral custom, and this, though this is a part of customary law, it will not be respected. Custom should not be immoral, it should be moral, then only it will be respected by law, and that's why custom of sati, which was immoral, custom of polygamy was immoral, custom of devdasi is immoral, okay. Lots of customs relating to transgenders, they are immoral, so they are not respected by law because they are immoral. Next thing, it should be continuous. So if custom breaks in between, okay, so if it is followed for 10 years and then it is stopped for next 10 years and then again followed, then it will not be considered as a source of law, and it will not be respected in the form of legislation, or it will not be codified. So that custom must be a continuous type of custom. Number four, it should be consistent. There should be some consistency in that custom. So for one people one custom and for another people another custom, it will not be allowed. So that's why certain very local customs are abolished. It should be certain, it should be specific, it should not be vague, okay. So it should be definite that this custom will be followed throughout the India and then it will become a part of India, it will become a source of law. For example, custom should be certain. For example, custom of Saptapadi, those 7 fere are done in all the Hindu communities throughout India. So that custom is certain. It is something which is not vague or uncertain. So custom should be certain. After that, it should be compulsory. Again, some example of Saptapadi, it is mandatory in marriage ritual. It should not be something which is voluntary, or if you like it then follow it type of custom. It should be something which is obligatory or mandatory on people. Next thing, peaceful enjoyment. People must have enjoyed that custom peacefully over the generations. So people must follow that custom without any opposition. Lots of customs are opposed. For example, sati, as we discussed earlier. So it should be peacefully enjoyed by the community throughout the centuries. Next thing, it should not be against public policy. So custom should go in accordance with your law. If it is against your law or against your public policy, then it will not be considered as a source of law. I forgot to mention one more point. Custom must be reasonable. It should not be something which is unreasonable or which goes beyond limits of a human being. So it should be reasonable. So these are the characteristics of a custom or a good custom, and a good custom will be respected by law. So if these characteristics are there in a custom, then it can become a source of law. When it becomes a source of law, when it is recognized by your law. For example, personal law, which is recognized by your legal system, then only it will become a source of law. So after covering all these points nicely, we are going to conclude that in India, there are various sources of law, but custom is one of them. All the customs are not a source of law. Only certain customs are source of law. So there is a classification of custom, that a custom having a sanction of law and custom which is not sanctioned by law. So some customs are banned by law and some customs are respected by law. There are two theories which provides for custom and which opposes customs. Okay, and there are certain ingredients which must be there in a custom to become a law. Regarding case law, you can drag so many case laws from personal law, okay, from Article 25 of the Constitution of India. So you can provide all these examples. Remember, providing illustrations also matter. Like in the, as I told you, A and B, a boy and girl, they get married, they perform Saptapadi in front of a pujari or priest. So illustrations are accepted. So if you don't remember a case law, provide a proper illustration like I provided. Local customs, wearing a sari, okay, it is not respected by law. right? So that type of custom, only certain customs are respected. So provide illustrations, and you can drag so many case laws from historical school, okay, from article 25 of the Constitution of India, from Hindu law, from Muslim law, triple talaq case. So many cases are also there. So write a proper answer and score well. So that's it for the day. Stay home, stay safe, do not go out without wearing a mask, and goodbye till my next lecture.